Hello viewers, this is me Shweta Reddy, Senior Journalist, and today is Vijay Sharma ji, Supreme Court Advocate, as usually with me in the Skype to discuss about a very important section. As we all know that June 14th, the death anniversary of the most famous Bollywood actor Sushant Singh Rajput. And as we already know that the whole story is being run around the drugs. And the police has also filed case on Rhea Chakraborty under the section 27A. So today we are going to know about the importance of section 27A, the Narcotic Drugs and Psychotropic Substance Act. Sharma ji,
Swetaji, under the NDPS Act 1985, Section 27A is a definition of the punishment of the drugs which are being purchased or which are being consumed, which has been purchased for consumption. So, the prohibited drugs, if being purchased and consumed, the punishment of the same has been enumerated under section 27A, which is maximum 1 year and a fine of 20,000 rupees. Whereas if the prohibited drugs under the NDPS Act is being found and traded, then the offense as regard to the commercial quantity has been enumerated under section 22C, and under section 22C the punishment for the commercial quantity is minimum 10 years, which can be extended to 20 years, and fine of rupees 1 lakh, which can be extended to 2 lakhs. So difference between the prohibited drug purchased or consumed under the NDPS Act 1985 is that if the drug has been purchased or is being found for consumption, the sentence is maximum 1 year. Whereas if the prohibited drugs under the NDPS Act is found, that is called commercial quantity, then the punishment is much larger, that is minimum 10 years, and which can be extended to 20 years and plus fine year also. So the relevancy is of the section 27A is because latestly we can see the Bombay High Court discussed and decided the bail application of Rhea Chakraborty, wherein it has been clearly observed by the High Court that the drugs has not been seized by the narcotic department and drug did not find there, and she was not having the possession of the drug either of consumption or of commercial quantity. So the High Court on this observation granted the bail to Rhea Chakraborty. The question comes, why the police or the narcotic department is not able to decide or understand whether a FIR should be lodged under the commercial quantity or consumption quantity against somebody. So it was a clear case wherein no drugs was found in the possession of Rhea Chakraborty. So when the drugs was not found, so there is no case made out, and that what is the observation of the High Court is. So section 21A is when somebody purchase the drugs prohibited under the NDPS Act and consume it or if he has not consumed, it was found in the possession, which is the quantity which can be consumed, then the punishment has been clearly enumerated under section 27A. That is, I'll repeat it, 1 year and 20,000 rupees. Whereas if the commercial quantity is found in the possession of the trader or anybody under the NDPS Act, then the punishment is much larger. That has been mentioned under section 22C of the NDPS Act. So there is a huge difference between the punishment of the drug which has been found in the possession for the consumption and which has been found for the trading, that is commercial quantity. There is a huge and drastic difference. Whereas in the drug found for the consumption is for 1 year, whereas if the drug found for the commercial quantity is 10-year minimum, which can be extended to 20 years. So this is the major issue which has been discussed also and which is relevant also. So I think one of the prominent point which can be discussed here, when the quantity did not find, the police or the control bureau, narcotic control bureau did not find the quantity. Why? They have lost the FIR. Why they have implicated a innocent person and dragged for months together in the court, and they could not find. Ultimately, when there is observation in the High Court, there is less likelihood of punishment under that particular section also, because the observation has already come. So that the benefit of that observation will be taken up in the defense by Rhea Chakraborty. So the relevant question is, why the agency, whosoever is implicating, accused or a person, why they are not ascertaining, why they are implicating them only on suspicion? Why there should not be certainty? Because their certainty.
I have a query on this. In so many cases, when you see the sedition case on Vinod Dua, when you see this narcotics registration of section 27A, filing of section 27A on Rhea Chakraborty, when you observe all these cases, we can come to understand that there is a lot of communication gap between the law and bureaucracy, between the law and the police. How will this gap get cleared?
Yes, you have raised a very important issue for the reforms, and that is a fundamental reforms in the criminal jurisprudence, because if the FIR has not been correctly drafted or correctly lodged, and the people have been falsely, or there is a scope of implicating people who are innocent, so there is likelihood that they'll ultimately be acquitted, but there is a lot of harassment by the time they already face. So this is very important issue. In my point of view, there must be an agency, like, or there may be judicial system